Order! Order! Order in my courts! Hey, you're taking orders? I'll have a Big Mac, some fries, and a Coke! You're in contempt of court. Throw him in a cell. Well, I'm already your prisoner. Alright, it's the digital prisoner coming at you. And guess what we're talking about? The Supreme Court and the rest of the judicial system. But we're going to focus mainly on the Supreme Court. Uh, the Supreme Court is the only court created by the Constitution. There are 9 members. 9. Okay? Why is 9 important? Exactly. 9 is important because it is an odd number. Because if you had 10, well, they could tie a lot. You want 9 so they don't tie a lot. So you want an actual decision to come. There are times where things rule 5-4 or 4-5, Um, and there's been 9 since 1869. These are appointed by the president and approved by the Senate. Okay, so that's part of that checks and balances going on. The president, whenever a current justice dies, retires, whatever, then the president begins searching for a replacement judge, and they find the judge, and then they bring it before the Senate and say, I'd like this guy to become president. And then he says, wait, no, wait, hold on, I'm president. I want this guy to become the next justice on the Supreme Court. And the Senate goes, hey, we can't put Bugs Bunny on the Supreme Court. I don't care how funny he is. No, but then they vote if they're going to appoint them to the Supreme Court or not. As a Supreme Court justice, you serve for life. Okay, you don't have to be elected. You don't have to go through elections. Once you're in until you retire or until you die. Um, and if there's some kind of fraudulent something going on, you can be removed. But usually it's you die or you retire. They're in session usually from about October to June. And they can only deal with matters that are brought to them in cases. Because remember, they're supposed to interpret the law, but unless a law is brought to them in a case, they can't interpret a law. Even if the law is unjust, they can't go do anything until a case is brought to them. Qualifications. Guess what? You could be a Supreme Court justice. Probably not, because there are unofficial qualifications. Though there are no official ones. Some of the unofficial ones is that you are a respected judge, or a lawyer or a legal scholar. That you are somewhere in the area of a law degree, and they take people who have a very deep knowledge of the law and of the Constitution. And then usually to be appointed by the president, you have to have certain political views that align with the president when a opening comes in. But you have to also make sure that you have a political alignment that aligns with the Senate as well, or with enough of the Senate so that you can get appointed. So there's a lot of politics to getting into this spot, even though there are no elections and no specific official qualifications. These are the current members of your Supreme Court. Uh, John G. Roberts. And why is there a CJ? Is that his nickname? No, that's not his nickname. CJ means Chief Justice. He's the big kahuna. He's the top dog. He's living large. And then you have Antonian Scalia, Anthony Kennedy, Clarence Thomas, Ruth Bader Ginsburg, Stephen Breyer, Samuel Alito Jr., Sonia Sotomayor, and Elena Kagan. And there you can check out the Supreme Court's website. They have biographies on all these people. It talks about rulings they've done in various years and so forth. You can read the dissents and everything else. All right, judicial review. This is the Supreme Court's power to decide if acts or laws of the executive and legislative branches are constitutional. Remember, they can't just go out and rule on something unless it is brought to them in a case. Um, and where the power of judicial review came from, this was in the famous case of Marbury versus Madison, which happened back in 1803. Uh, to give you a little bit of history about this, um, John Adams was president. Thomas Jefferson had just uh, defeated John Adams, and there's a period of time from whenever the next president wins the election, and the current president actually leaves office. There's a little bit of area there, and so during this time period, um, Adams passed the Judiciary Act of 1801, which appointed a bunch of new judges in district courts um, to be sent out. One of the people that was supposed to get a letter appointing them to a position in the courts was a guy by the name of William Marbury. Um, Now, all these appointments had been made and approved by the Senate. They were written up to be sent out. And it was assumed that um, the next Chief Justice coming in, uh, Madison, would send these appointments out since they had all been done through proper legal matters. Well, they were ordered by Jefferson not to be sent out, and so Madison didn't send it out. And so this went to court as Marbury, the guy who wanted his appointment, versus Madison. And when this got to the Supreme Court, uh, they ruled that it was um, illegal for Madison to refuse to deliver the commissions uh, since they had been done legally. However, they didn't make him give it back uh, because they ruled that the Judiciary Act of 1801 had been illegal or unconstitutional. Um, since it was trying to make the court's power more than the Constitution had given it. So this is where the play of judiciary review came in. They began ruling laws unconstitutional that no longer are that didn't follow the Constitution, and it gave them this very powerful tool to use, judiciary review. And these are also known as the midnight appointments because they were all appointed there late and um, written up right there at the last moment to be delivered at the next presidency's term. Supreme Court cases. They rule on about 150 cases a year, and about 8,000 are appealed to the Supreme Court every year. So they get about 8,000 sent to them. They choose about 150 and rule on them. Two courts ruled differently. All right, and these are some of the cases that they might get. For instance, if the initial court ruled in favor of the prosecution, whereas the appellate court ruled in favor of the defense, the Supreme Court might take this case in order to settle it between the courts. Um, a lower court ruling conflicts with the Supreme Court. Let's say that the Supreme Court had previously ruled on something, and then the lower court makes a different rule that goes against kind of what the Supreme Court had ruled. Well, then that would go on up to the Supreme Court. And they like to hear these to either reinforce or change some of the previous rulings. Um, and in cases that have very high social significance. And a lot of these kind of cases are, gay marriage, the Obamacare issues, um, and things like that, abortion. So a lot of cases like that with very important social significance tend to the go before the courts or the Supreme Court because they like to rule on these major issues. And they do about 1 to 3 cases a day, and they operate Monday through Wednesday. And it is public. Don't you wish you had a nice job that you could do for the rest of your life that worked Monday through Wednesday, October to June? That'd be pretty sweet. All right, so here in a case, 6 justices out of the 9 have to be present. They read written arguments that have been submitted to them, and then each side of the argument gets a 30-minute oral argument. So they can stand before the judges and kind of like whenever you hear in court, you see them on TV or so forth, they give their opening and closing statements. It's kind of what this is, but wrapped into one. They give a statement. There's no witnesses and stuff like that. Usually it's just these statements that are prepared. And then the judges get to question the attorneys. So the judge asks the questions that they have concerning, what about this and that, so they can get some more. And then it's decided by a simple majority. So if there are 9 judges, if 5 judges vote for and 4 against, it passes, or the judge's support goes to whoever has the majority. Opinions, okay? Opinions are the decisions of the court. They are written by the most senior judge on the majority side, and they become legal precedent. So if like the chief justice is on the majority side, he's going to write the uh, major opinion, and this is what will become, in essence, law, legal precedent. This is what other courts will go by because this is what the Supreme Court ruled. So if you've ever seen on TV and some of these law shows or people start quoting, well, in Jane versus John, this happened. Well, they're referring back to legal precedent that was set in a Supreme Court case. Concurring opinion. This is somebody who writes an opinion. They agreed with the majority. They voted the same way, but they agreed for different reasons. They said, well, I didn't vote for it because, you know, it was a hill. I voted for it because it had grass on the hill. I mean, I'm just making stuff up here. Um, so they write why they voted for it. Uh, that was different than why the rest of the majority voted for it. And then there's the dissenting opinion, which is on the minority side, um, voicing why they did not vote for this. All right, criminal versus civil law. And you hear this, and I remember as a kid, during the O.J. Simpson trial, it was like, oh, well, he was found, innocent in the criminal case. Oh, but he was found guilty in a civil case. And I was like, how is that? Well, it's the difference between criminal law and civil law. Now, criminal law deals with breaking of the laws, and proof uh, of burden is to prove that you are guilty because it's the whole saying is you're innocent until you're proven guilty. Well, that is criminal law. Now, civil law disputes between people or other entities over money, property, or something of value. And so there is less of the burden to prove that you're guilty. You almost kind of have to prove, hey, I didn't do that, or um, it's less as thorough as criminal law. And like you can be tried for something in criminal law, and if you look at your amendments, your Bill of Rights, you can't be tried for the same crime twice. That's in criminal law. If I'm tried for it as a criminal law and I get off, like O.J. Simpson did, he was found not guilty. Well, I can still be sued in civil law for wrongful death or something like that, which he was, and he was found guilty in the civil court. So that's kind of the difference between criminal and civil. Terms. A plaintiff. It's the party that begins the legal case. The criminal plaintiff, or in criminal cases, the plaintiff is the government. The defendant is the party who is being charged by the plaintiff's claims. So if you are claimed to have killed somebody, you would be the defendant and the government would be the plaintiff. If it was a civil case and let's say you owed me $10,000, well, um, I would be the plaintiff going after my $10,000 from you, who would be the defendant. Appeals is the process in which the non-victor of the trial requests a higher court review the decision of the lower court. There are appellate courts, and we'll look at the court hierarchy here in just a minute. Um, and so it can go to these courts, and it can continue to go up until the final court, which is the Supreme Court. And then jurisdiction, authority over cases in certain geographical locations or specific types. Um, like the appellate court has jurisdiction over appeals. Uh, Courts, if you get for example, if you get a speeding ticket inside of a specific city, well, you have to report to that city's court. But if you're outside in the parish, you have to report to the parish court. Okay, that is their different jurisdictions. All right, interpreting. Courts interpret laws, meaning that the decided what exactly a law means as it pertains to each case. Words like reasonable make laws open to various interpretations. Okay, so sometimes a law will say, that you have to reasonably do this, and so the judges have to figure out what is reasonable. That he took off running, trying to reach it in time. He made a reasonable effort to attempt this. Or they could say that, hey, the guy just, he piddle-daddled around, he walked, he stopped, he looked at his phone. So he didn't make a full attempt to get there. So it wasn't a reasonable attempt, so we find him guilty or whatever. So, judges have to kind of interpret laws like that. And they use precedent to help make their decisions. So they look at what previous rulings were, what judges before them had ruled, to kind of get an idea of how to go with what reasonable means. So, and this is the court system. On the right-hand side, over here you have local trial courts that lead up to state appeals courts, and then it goes to the highest state court of appeals, which is usually like a state supreme court, because all the states have their own like top court, and usually it's like state of Louisiana, the Supreme Court of the state of Louisiana. Or it can go to a federal district court, if it's a federal trial, and it could go to a specific district court for the federal court system. And then if you appeal that, it goes up to the federal appeals court. And then ultimately, they both wind up at the United States Supreme Court because, remember, that is the highest court in the land. Federal jurisdiction. They have jurisdiction over any trial that deals with the U.S. government, with the United States Constitution, federal laws, controversies between states. So if Louisiana had a problem with Mississippi, that would automatically go into federal court. Controversies between the United States and foreign governments. So if there was a issue between somebody here and a foreign entity, that automatically goes to the federal courts. Citizens of other countries. So if somebody else is here visiting from another country, that automatically goes to federal court. And then bankruptcy and other specialty areas. That is kind of the federal wheelhouse. That's kind of their jurisdiction. So until next time, kind of like my old pal Judge Dredd says, I am the law. Deuces.